Since November, much of the media focus has been on the clash between the White House and the new Democratic Congress. But in our third story in the countdown, one attack and one retreat tonight in President Bush's ongoing war with the nation's judiciary. The administration appears to be purging at least 7 U.S. attorneys with virtually no public explanation. California Senator Dianne Feinstein suggesting one of them, Carol Lamb, had subpoenas out for some members of Congress after already having taken down Duke Cunningham. Feinstein also raising concerns about how Lamb and other prosecutors will be replaced. A tiny provision slipped into last year's version of the Patriot Act reauthorization lets Attorney General Gonzales appoint interim replacements for indefinite periods. Prior to last year, interim prosecutors were appointed by federal courts. Gonzales claims that the judges tended to appoint their friends. Meanwhile, one of his appointments turns out to be a 37-year-old whose resume reportedly includes helping the RNC dig up dirt on Democrats. Mr. Gonzales will testify about all this tomorrow and possibly also about another swipe at the judiciary branch today, talking about what he and the president look for in judicial nominees.
We want to determine whether he understands the inherent limits that make an unelected judiciary inferior to Congress or the president in making policy judgments. That, for example, a judge will never be in the best position to know what is in the national security interest of our country.
That statement followed later by Gonzales and the president backing down to a judge who said their warrantless wiretapping program was unconstitutional. Mr. Gonzales announcing that the program is now being run under the oversight of the Foreign Intelligence Surveillance Court, which is precisely what the president insisted could not be done without endangering American lives. That is, back before Democrats in Congress won the subpoena power necessary to find out which officials might be violating the Constitution. It's all making your head spin. Imagine what it's doing to our favorite constitutional scholar, Professor Jonathan Turley of George Washington University. John, thanks again for your help tonight.
Thanks, Keith.
Let's start with the prosecutors. The purge itself seems frightening enough, but flesh out Senator Feinstein's concerns about the replacement mechanism.
Well, you know, the system that we used for a very long time was that a federal judge would pick an interim replacement, but that the ultimate U.S. attorney, the one that would take the position permanently, would go through the Senate confirmation process. What happened in the 109th, when Congress was jettisoning virtually any role in government, is that they gave to the president the right to essentially replace any sitting U.S. attorney indefinitely. That circumvents the confirmation process. So they really could appoint virtually anyone. They could appoint a hack, they could appoint a moron, they could appoint, you know, someone like Brandeis, but we would never know whether they're a Brandeis or whether they're adult because they won't go through confirmation.
I'll vote for moron hack. The Attorney General has this paper trail of hostility towards the judiciary, but the remarks about judges and national security, any idea what the target is there? Is he trying to demote judges below the other two branches, or is this more subtle than that? Is he trying to demote issues of constitutionality about which judges are supreme below the issues of national security?
Well, you know, Gonzales has always acted more general than attorney in his position. He seems just inherently hostile to the rule of law. And this administration for a long time said the problem was with these defendants. They shouldn't be allowed in court. And then the problem became the attorneys, and they prevented attorneys from meeting them. Then the problem became habeas corpus. And now the problem is the judges. And what's exactly left? I mean, everything is the problem because they're acting outside the rule of law. And so they're really hearing whistles down the track here, one coming from Congress, one coming from the courts, and both saying the same thing, that this president has been routinely and flagrantly violating the Constitution that he took an oath to uphold.
All right, so that leads us nicely into the warrantless wiretapping decision. Has the White House said that the court has been upgraded, it operates quickly now, and so they can go to that? Is that the reason that they reverse gears on it, or is the administration showing signs of nervousness about which of its members would get the first subpoena?
Well, I think it's the latter. The fact is that Gonzales went to all these hearings and said despite the overwhelming opinion of law professors that their NSA domestic surveillance program was clearly constitutional. But what the public didn't see was that every time that question went before a real judge, the administration did everything they could to take the case away or keep the judge from ruling because they knew that that was all ridiculous, that they never did have the authority. And so now they're doing what they should have done, but they're gaming the system. They keep on fighting this, pretending they have a legal precedent on their side, and they pull out. They did that with Jose Padilla. You know, they insisted that they had every right to hold him, but when a judge finally got around to looking at what they were doing to Padilla, they just withdrew that case and charged him with something else. It's gaming the system. I've had clients, petty criminals, that did that. They just game the system until the very point where they'll be held responsible, and then they change course.
And lastly, something that the update on the story that you and I were talking about on Monday, Charles Stimson, Kelly Stimson, the Pentagon official who was talking about the prospect of a boycott of law firms that were to defend the detainees at Guantanamo, apologized today, wrote a letter to the Washington Post saying he was sorry. Is that enough to put the toxic toothpaste back into the toxic toothpaste tube, or is it impossible to unhint a boycott?
Well, first of all, it wasn't a very good apology, but the message had already been delivered. He could apologize, but the message was already to those executives who were in favor of the administration that they should start to put pressure on these law firms. And you'll notice that when this guy was giving this non-apology apology, Gonzales at the same time was pointing to him positively and saying that he's complaining about all of these darn appeals and objections and how it's delaying us, and pretty much supporting him implicitly. The only solution to someone like Simpson is to fire him. And I can't imagine what he has to do to be fired.
Well, let's find out if you can impeach somebody in that position, because that's the only way he's going to go. Jonathan Turley, constitutional law professor at George Washington University. As always, great thanks for your time.
Thank you, Keith.